Hello, everyone. I guess we could begin. Let me start by saying that I will be unable to check my email at this time because it's difficult to be looking at multiple screens all at one time. So I've purposely turned off my emails during the tutorial session. However, I could certainly read your chats in the chat box, and then you're free to use the mic if you want to say anything. And so let me also begin by welcoming everyone to tonight's session, and I'm glad that we have quite a number of people who've joined tonight's session as well, where we will be discussing merit review and administrative tribunal. So that's going to be the topic for tonight. But before we begin discussing the tutorial problems that I've prepared, I'd like to spend a few minutes to answer whatever questions you might have. Let me begin, though, by speaking of the special tutorial session on the legal memorandum assessment. So we had a number of students suggesting that we have a special session on it. Melissa Elwood, for example, made that suggestion, as well as a few others. So I have agreed to, and I think it's a good idea for us to have a special session to just cover the legal memorandum assessment, because that would comprise 40% of your final grade. So we're having one on Friday, this Friday at 6 o'clock up to 7 p.m. I just noticed now, after one of you sent me an email, and who was that? It could have been Catherine. Yeah, it might have been Catherine who pointed out that I actually failed to indicate when the special tutorial was going to be. So we're going to hold that on Friday this week from 6 to 7. After the session, I will stay on for another 30 minutes just to take any questions that you might have or points you would wish to clarify. In the special tutorial session, I want to be clear that I will refrain from providing the answers. The most I can do would be to guide you, because otherwise, if I give you the answer, what's the point of the legal memorandum assessment? So I'm just going to be there to guide you, help you perhaps identify some of the legal issues, point you towards the direction of what specific cases to look at. But beyond that, that's going to be your job. Okay? So that's going to be the purpose of the special session on Friday. And we're going to take a look as well on the IRAC and CIRAC format. So we're going to look into that as well. Okay. Anything else?
Hi, Manjo. It's Jason.
Jason, yes.
Just when we go through the tutorial tonight, I assume you'll be going through the notes for the first part of the week first and the second part second, since there's two lots of notes. Is that correct?
Not exactly, because I've only limited myself to a few problems, because there are many problems there. How many questions were there? There must have been about 5 or 6 of them. So we don't have enough time to cover all the tutorial problems. However, we've actually got about 4. So it's possible we'll go through all of them. So we've got 4 tutorial questions. I'm not sure if we're able to cover the 4 of them, but I will be posting the answers 1 week from now. So assuming that we're unable to cover all the discussion questions, the answers will be posted in Moodle the week after next. So let's say today would be the 7th. I could post the answers on the 13th. I wonder if that might be too soon. I could post them on the 13th, just for you to have a sense of where you're at in terms of your answers, whether you're in the right track or not. So I'll probably post the answers on the 13th of December, Sunday. But certainly,
I think that'd be really good. But can you also post the recommended answers for the weeks gone by? Might give us a bit of a hint for our assignment. You said you're going to do that also?
Yeah, I actually did. I've already posted the answers to the week 2 questions. They are now in Moodle. So if you look at the
Excellent. Thank you.
Yeah, they're there. I did not provide any answers to the week 1 questions, mainly because those were just introductory questions. And there was no point in coming up with a suggested answer, because there really isn't any single suggested answer, because they were mainly based on the principles. And we could just go through the tutorial session itself. But as far as the problem-based questions are concerned, I've already posted the answers to the week 2 questions, and I will certainly post the answers to the week 3 questions on the 13th, or in other words, at the end of this week. So I'm going to delay it a bit, because I'd like to give students an opportunity to post their own answers without having to be influenced by a recommended set of answers. Okay. Anything else before we proceed? None.
Manjo, can I just ask a question? It
Yes,
might seem like it might sound like a dumb question, but I was wondering, given you have a choice of well, not so much a choice, but you have merits review and judicial review.
Mhm.
For the life of me, I cannot understand why anyone would want a judicial review when it appears that a merits review seems to cover everything. Am I missing a point somewhere?
Yes, you are. Yes, you certainly are. Who was that? Sorry, I couldn't see who was asking.
Erin.
Erin. Okay,
Erin.
thank you for the question. Let me just point out before I answer your question that there is never any question that seems stupid. In fact, by raising that question, you're giving your classmates an opportunity to learn more about the subject. So that was a very crucial question that you asked. So I thank you for that. And again, this is just a signal to everyone that there is never any stupid question. That question was really good. So thank you for that. Now, why is it important? As pointed out by Erin, right? So as pointed out by Erin, why would people go for a judicial review when merits review seems better? Because especially if you look at it from the viewpoint of the fact that a merit review examines the factual matters, and merit review is also more expansive in terms of the powers of the tribunal, because the tribunal can actually step into the shoes of the original decision maker. So in that case, there is more power on the part of a merits review tribunal, of an administrative tribunal, not only to in relation to what it can do, because it can actually remake a decision and put its decision in place and substitute its decision in place of that of the original decision maker. So that's crucial there. Whereas if you look at judicial review, the most of the judicial review can do will be to either set it aside or remit it perhaps to the original decision maker to have a look. But the judicial review cannot remake a decision of the decision maker. The judicial review also cannot compel the decision maker to act in a certain way. So for example, in relation to benefits that might be claimed by an applicant, even assuming that that courts, Chapter 3 courts, will agree that the applicant is correct, it is not within the power of judicial review, therefore, to order a decision maker to act in a specific way. So therefore, it seems to be logical that in that case, why shouldn't one apply for a merits review instead of a judicial review, especially when you consider that it is more expensive if you go through a judicial review process, because you need to hire lawyers, and it could, it probably takes longer to resolve if it's a judicial review, and you have the process, you have the judicial processes, which certainly are not easily understood by laymen, because there are certain formalities and rigidity in the procedure. Whereas if you look at merits review, things seem actually. That was actually part of my question. Hold on. No, I removed one of the questions. So there are a lot of reasons why one would go for a merits review instead of a judicial review. So why wouldn't one go to a merits review instead of a judicial review? And we have answers from the classmates here. Okay. I'm just going to insert a new slide there. And I'm going to pick up the answers from the class. Hold on. Okay, so this is from Rice. So I'm putting it on the screen mainly because those who might be viewing this recording will not be able to see the chats, because the chat is saved in a separate file. So that's why I'm just putting them on the screen here. And then we'll answer some questions here. Is that it? Okay, so the main reason why you'd go for judicial review and not merits review, for example, is that merit review is not always available. So in other words, as we know, if you look at the Administrative Appeals Tribunal Act of 1975, it is quite clear that the only instance when an administrative decision is subject to review by the Administrative Appeals Tribunal is if a law, not the AAT Act of 1975, if another law specifies that recourse could be had or could be made to the AAT. So in the absence of a specific legislation stating that an administrative decision is subject to a review with the AAT, then merit review is not available. So let me repeat. Merit review, we're talking here at the federal level, we're talking of the administrative appeal, the applicability of the merit review under the AAT Act of 1975. Administrative review or merit review is only available when a specific legislation specifically states that recourse could be had to the AAT for the purpose of reviewing a decision. So in the absence of a specific legislation to that effect, merit review is unavailable. Secondly, as Tawa pointed out here, a lot of it also depends on the type of decision that is to be reviewed. So in other words, it has to be an administrative decision. So if it is not, then you cannot have a merits review. Okay, now the other point to be considered is that, hold on, was it asking me to leave the meeting? A lot of it also depends on what you are trying to achieve. So in other words, this is actually more this point is actually more pertinent in relation to judicial review, in the sense that because judicial review is has a limited scope of review, and it looks specifically only at errors of law and not on facts, and not errors of facts. You also have to look when thinking about whether judicial review is available. You also have to look at what exactly is the remedy that you're asking the court to give. If you're asking the court to act in a specific way, for example, to ask the court to order the payment of benefits, the court will be unable to do that, because typically what the court does is simply to nullify a decision or perhaps remit a decision back to the original decision maker. If you look at the Administrative Appeals Tribunal Act of 1977, there is a portion there where the courts may actually ask the decision maker to act in a specific way. But again, if you look at it from the viewpoint of the decision of the court in Green versus Daniels, the High Court there pointed out that even if it were inclined to grant the specific remedies that were sought by the applicant there, because on the basis of law he was correct, the High Court did point out that it was not within the scope of a judicial review to order the decision maker to act in a specific way, because, as we said, the nature of judicial review is quite limited, and judges cannot step in the shoes of an original decision maker. Neither can judges substitute their own decision for that of the decision maker. There's a question, can merits review not assist in resolving an error of law? Only in a very limited way. If you look at the case of Brian Lawlor versus, if you look at the case of New South Wales Collector of Customs versus Brian Lawlor Automotive, the court ruled, the High Court ruled that it is within the power of in the course of doing a merits review, the administrative tribunal can incidentally pass upon questions of law. So in other words, the mere fact alone that there is an application for merits review with an administrative tribunal, the fact alone that a legal question seems to have been raised, or there seems to be a question involving an error of law, the mere fact alone that a legal question or an error of law has been raised as a ground of appeal will not mean that the administrative tribunal therefore ceases to have the power to undertake merits review. It still can. However, so in other words, it does not lose its jurisdiction simply because there seems to be an error of law that has been raised by one of the parties. The High Court ruled that it will continue to have jurisdiction. However, the findings of any administrative tribunal in relation to errors of law are always never final because only Chapter 3 courts. Is there some noise there? Okay. Sorry, actually, Catherine, that was my son tinkering around. I was trying to get some medication for his injury. He was playing scooter. Okay, so where was I? What was I talking about? Yeah, so as the case of New South Wales College of Customs versus Byron Lawler is concerned, yeah, only Chapter 3 courts actually have the power to make determinations as far as legal questions are concerned, not merit tribunals or not administrative tribunals. So the power to interpret laws lies exclusively with Chapter 3 courts and not administrative tribunals. Okay. Anything else? Questions? None? So we could begin with, I'll skip the key outcomes because it's there. I wonder if we had covered this already. What do you think are the defining characteristics of merits review? We'll just skip that because I kind of covered it when I discussed the question earlier. Let's see. Okay, here we go. Let's just briefly think about these two questions. And that somehow relates as well to the question that was posed earlier as to why anyone would go for merits review. So as I pointed out, it's never just a question. It's not simply a question of merits review being better. It's really a question of, will the law allow merits review in the first place? Because you can only have merits review if you have a law that specifically provides for an application for review to be made with the AAT. So therefore, you know, it's limited. Whereas if you look at judicial review, we remember that you don't need a specific legislation to say that judicial review is available. Because, at least from the viewpoint of two aspects of a source of law, you can have recourse to the Constitution, specifically Section 75, subsection 5 of the Australian Commonwealth Constitution provides that where writ of prohibition, mandamus, or injunction is sought against an officer of the Commonwealth, then the High Court has a power of judicial review. So you don't need specific legislation providing that judicial review should be available. Whereas, if you speak of merit review, there has to be specific legislation providing that recourse can be had to the AAT. So that's one distinction there. But more importantly, we must remember that courts have always exercised a power under common law to temper or to control the exercise of the powers by the executive government. So even if there were no Australian Commonwealth Constitution, so even if it had not existed, such as in New Zealand, for example, because New Zealand has no written constitution, even if there were no specific constitution or no specific constitutional provision that provided for judicial review, chances are the courts historically would have intervened to temper or control the exercise by the executive government of its executive power. So it is an inherent power of the courts exercising their common law jurisdiction to actually control the exercise of executive power by the executive, even in the absence of a constitutional provision or specific legislation to that effect. And we are able to make that conclusion because in New Zealand, for example, New Zealand does not have a written constitution, but still there is the common law jurisdiction which lies with the courts to be able to review the exercise of executive power by the executive. Okay, so let's try to answer this specific question now. Are administrative tribunals such as the Administrative Appeals Tribunal part of the judiciary or the executive, and why? And two, why is it even important to ask which branch of government an administrative tribunal belongs to? Okay, so those two questions there. Yep. Okay. Okay, so we seem to be clear, yes, and we have a specific answer here from Maggie or from Margie. Is that Maggie or Margie?
It's Margie, but
Maggie.
it's okay. You've been calling me that for a long time.
So Maggie would be fine, right? Because remember one of the emails we had, you kind of mentioned Maggie.
I answer anything. It's all good.
Okay. Okay. So as Maggie pointed out, the Administrative Appeals Tribunal is certainly part of the executive, and it is within the portfolio of the Attorney General. Good. Now, why is it important to ask whether or not a branch of government, whether or not a tribunal actually belongs to the judiciary or the executive? Why is that important? And we've got a fantastic answer from Rice. There is a statement by Chief Justice Spiegelman, I think of the New South Wales Supreme Court, that the administrative tribunals should be looked at as a fourth arm of government. So why is it crucial to know whether a specific tribunal, sorry, let me rephrase that question. Why is it important for us to determine whether a tribunal belongs to the executive or the judiciary? So why is it even important to ask which branch of government an administrative tribunal belongs to? So we've got jurisdiction, we've got independence from interference, separation of powers, okay. But why? So what has separation of powers got to do with this? Okay.
Because it's supposed to be seen as an independent tribunal, not influenced by the executive or the judiciary.
Okay. But that raises the question there. I'd like to ask you, do you suppose that the AAT is actually not independent? And that the AAT can actually be controlled by the executive? Are we making that suggestion?
I think it's very easy to draw the conclusion that if a division or department is sort of subject to higher ranking decisions, well, of course they're going to be influenced. So the need for independence is pretty much vital.
Okay, but let's follow that further, because that's a crucial point here. We're talking of the independence. A decision of the AAT, is that subject to a review, for example, by the Prime Minister or somebody within the executive department?
Well, I guess at any stage the Parliament could review any act and change it to their will if they wanted to.
Okay. I'm just asking questions here, just for us to have a grasp of what's going on. Because that notion of independence actually is one of the reasons why they decided to come up with the AAT. In a sense, to have a quasi-judicial tribunal that had exercised some semblance of independence. Independence from political interference. Obviously, not fully, because as some of you pointed out, Vivian, for example, says that there is, to an extent, some interference in the sense that the executive determines tenure and pay rates. So to a great extent, they don't influence decisions of the tribunal directly, but by determining who will sit in the tribunal, especially because members sit for 7 years, for example, the executive can actually determine, what kind of, how the AAT will actually proceed by determining who will sit in the tribunals in the first place. Okay, but certainly the assumption is the AAT is meant to be an independent body, independent even from the executive. So even if it belongs to the executive, the proper viewing should be that it is actually independent from the executive. It is part of the executive, but it is independent from the executive, and it is meant to be not susceptible to interference by the executive. I mean, not directly. Indirectly, it could be because there's a question of reappointment, there's a question of pace, and so on. But certainly, as a matter of principle, the decisions of the AAT are meant to be free, are meant to be independent and free from political interference, because it is a quasi-judicial tribunal. To a great extent, it might be argued that its decisions can be influenced by decisions of the executive government in terms of what the national policies might be, but only to a limited extent. The executive, it will be the AAT will fail in its attempt to show itself as an independent tribunal if it were to be openly and directly influenced by the executive. So that is not who it will be. It is meant to be independent. Now, but we go back to the question I posed earlier, why it was important to even ask which branch of government an administrative tribunal belongs to. That was a question I asked, and a lot of you had raised the point about separation of powers. Can somebody just kind of explain to us, how does separation of powers answer this specific question of why it is important to ask which part of government an administrative tribunal belongs to?
Manjo, is it because it's only allowed to make this, it's only allowed to review administrative decisions? So in that respect, you need to know which branch it belongs to be able to be effective?
Partly, but not that. But that wouldn't be the most the ideal reason. Anyone else?
Manjo, I feel it's because with the separation of powers, obviously the judiciary are seen as the authority over issues of law, and there's a limitation on their jurisdiction in as far as they are not able to stand in the shoes of the executive, so that they're not attempting to usurp the powers of the executive, whereby under merits review, which is undertaken by an arm of the executive government, they do have the jurisdiction to stand in the shoes of the executive and to actually make their own definitive decision, which may be different from the decision that was made originally.
Thank you. That was a closer answer. Thank you. Who was that? I couldn't see from the screen.
Oh, that was Libby.
Libby. Thank you, Libby. Thank you. That was quite close. You know, a lot of information. And you were correct. And but I'd like also to recognize a statement here by Tawanda or Tawa. Is that fine, Tawa, or should I call you Tawanda? Tawa, I think I saw an email from you. You said Tawa, and please correct me if I'm wrong. But I've got a statement here from Tawa that administrative tribunals cannot act as Chapter 3 courts. Tawa, if you could, can you just explain your answer here?
Thank you. I think because of the Boilermakers doctrine, the administrative tribunals that are part of the executive cannot act as Chapter 3 courts because it's outside their jurisdiction and because of the doctrine of separation of powers.
Thank you.
Thank you.
Thank you, Tawa. That is the correct answer. So the High Court has ruled in the Boilermakers case that judicial power can only be exercised by Chapter 3 courts. So when you speak of so I'm raising this point because when you study administrative law, there is an area where there is an intersection between administrative law and constitutional law. And one of those areas actually relates to the notion of separation of powers. So it's crucial for us to have an understanding of the notion of separation of powers. So as pointed out correctly, by Tawanda, in the Boilermakers case, the High Court ruled that judicial power can only be exercised by Chapter 3 courts. So in other words, these are courts that are constituted according to Chapter 3 of the Australian Commonwealth Constitution. So because of that, for example, there will be, if a court is meant to be a Chapter 3 court, there are certain formalities or certain requirements that have to be met for it to be a Chapter 3 court or a judicial court. A lot of these will refer to the type of persons who could be appointed. A lot of it will also be in relation to questions of what powers can actually be exercised by a Chapter 3 court, and questions of independence, for example. So if it's a Chapter 3 court, it can exercise judicial power, but if it is a non-Chapter 3 court, it cannot exercise judicial power. So what exactly is judicial power? Judicial power refers to the power of a court to make decisions where there is a right, an interest, or an expectancy that has been violated or breached by another party. So it refers to an actual controversy between parties which involves an actual controversy relating to rights, liabilities, or legitimate interests on one of the parties. So that would be when judicial power is exercised. Okay, so what exactly is a Chapter 3 court? A Chapter 3 court is a court that is constituted according to Chapter 3 of the Australian Constitution, and there are certain requirements in relation to it. Number one, unlike, for example, the Administrative Appeals Tribunal, where members of the AAT sit there usually for about 3 years, judges of federal courts will sit in federal courts up to the age of 70 years. And their tenure cannot be reduced. Neither can a judge of a federal court be removed from office, except according to the clear wording of the Constitution. Whereas, if you speak of a Chapter 3 court, it is permissible for the Commonwealth Parliament, for example, to indicate that a person may only sit in an administrative tribunal even for, let's say, for 3 years. It may also say in a law that a judge or a member of an administrative tribunal may be subject to removal for any reason. It could be for lack of confidence on the part of the executive. Certainly, that is not permitted when you speak of a judge of a federal court. In relation to removal, for example, as pointed out by Rice here, it requires both members of parliament to remove a member of the federal court from office. Whereas, if you speak of an administrative tribunal, it will be within the power of the Commonwealth Parliament to determine the grounds for removal. And the grounds for removal in that case could be for any reason beyond that, as stated in the Constitution. And at the same time, it can be stated that, for example, the Attorney General has the power to remove any member of the administrative tribunal unilaterally. So that would be one of the key distinctions there. But more importantly, the key reason is if the High Court has clearly ruled that the exercise of judicial power can only be done by federal courts and not by administrative tribunals. And so how do we see this in perspective? How do we exactly know whether or not we have a controversy and whether or not that will require the exercise of an administrative tribunal or a judicial court? So if it is a federal court that is attempting to exercise its judicial power, what it means is that there must be a controversy between parties. So you've got a plaintiff, you've got a defendant, or you've got party litigants. It could be between private citizens versus a corporation. It could be between corporations themselves. Whereas if you speak of an administrative tribunal, you typically have a single person there who goes before an administrative tribunal. There is no actual controversy against another person. There is no actual controversy as well, in the sense that there is no right or interest or legitimate expectation that has been violated. Because if there is an actual controversy involving the breach or violation of a right, interest, or legitimate expectation, if there is an actual controversy, therefore, as defined by the court in Huddard Parker versus Moorhead, then in that case, that controversy can only be resolved by a court and not by an administrative tribunal. And that relates to the notion, according to Vivian, of a matter. Good. Thank you, Brad. So Brad there has stated for us Section 71 of the Constitution, and he says the judicial power of the Commonwealth shall be vested in a federal Supreme Court, as well as other federal courts that the Parliament creates. So we won't go into detail on that. It's just important. We just discussed that briefly for us to have a better sense of why it is important to know that administrative tribunals actually belong to the executive. But we're not going to go into detail because we're not dealing with constitutional law here, just for us to have a sense of that point there. So moving on. So this is the next question I'd like to raise. I'm just looking at the time here. Okay, hold on. How many problems I have? Okay, we're going to do this quickly. Does anyone remember the distinction between the correct or preferable decision as stated by the Federal Court of Australia in Drake versus Minister for Immigration and Ethnic Affairs? Can somebody tell us? Or you could try typing in the chat box. Because in Drake versus Minister for Immigration and Ethnic Affairs, the federal court said that it is the function of an administrative tribunal to determine whether an administrative decision under review is the correct or preferable one. What does correct mean and what does preferable mean?
They use the term to mean if there's correct, that means there's only one correct one. When it's they use preferable, that means there are several options and the best of the many options.
Thank you. Thank you very much, B. And when we say that there are many options, why is it that there are many possible options? How do you arrive at a point where we can say that it is actually open to the decision maker to come up with possible answers or possible choices in terms of what the decision should be? When do we say that? There is actually more than one choice. There, okay, so from Vicky, preferable decision involves discretionary consideration. So when there is a discretion that is given to the original decision maker, so he can therefore exercise his decision. Let's say the phrase might be to his satisfaction, as he sees fit. That entails a discretion there. It could be according to policy considerations, as pointed out by Vivian. Then you have a wide spectrum of what a preferable decision is. Any of those, if it is within a spectrum or within the range of permissible decisions, then any of those decisions can actually be considered to be preferable. And in that case, judicial courts, Chapter 3 courts, will not make a choice of what the preferable decision should be because of the notion of separation of powers. Hold on, I'm just going to say something to my son because he's beginning to eat. He's making so much noise. Give me a second. Hold on. Okay. So we clear that, I guess. We'll move on. So thank you. Let's move on. Okay. Can I ask somebody to volunteer to read discussion question 2 for us, please? Can I get a volunteer to read discussion question 2?
Maggie.
Maggie?
Someone going to? No, that.
Then Sarah, I'll call on
Let someone else.
Go for Miss Sarah. Then the next question, I'll call on Sarah. Maggie, please. Can you read the discussion question?
The Financial Regulatory Agency, FRA, a federal regulatory agency that regulates the financial advisors industry, ruled that Mr. James Bull did not meet the professional experience requirement to be admitted as a registered financial advisor under the Financial Regulations Act, Commonwealth. Mr. Bull sought to challenge the decision in an application for review to the Administrative Appeals Tribunal. The FRA objected to the jurisdiction of the AAT on the ground that the AAT had no power to rule on a matter that involved a legal interpretation of the Financial Regulations Act. Is this objection tenable?
Okay, thank you, Sarah. Can I get the answers? Can I get your answers in the chat box, please? Okay, so good. So not tenable. How about the others? So we've got an answer from Brad, not tenable, no. Good. Okay, so that's the correct answer there. The objection is not tenable. Why is that so? Why is the objection not tenable? Can I get the answer now? Why do you think is objection tenable? You can use the chat box or you can say two answers by using the mic.
Is it because tribunals are able to look at questions of law as well as just fact? Okay, partly. Yes. But more specifically, why do we say that the objection here would be untenable?
Because the 3 jurisdictional requirements have been met. Okay. So the rule, the relevant case here would have to be New South Wales Collector of Customs versus Brian Lawler Automotive, where the High Court ruled, or was it the Federal Court? It was the Federal Court of Australia that ruled that the mere fact alone that there is a question of law that has been raised does not mean that an administrative tribunal or the AAT necessarily loses its jurisdiction. The administrative tribunal can still continue to adjudicate on the application for review, notwithstanding the fact that as an incident to its resolution of the control of the case, there is a question of law that is involved. Okay, the tutorial is recorded. I'm sure, or I think. Wait, it is. It's recording. I'm seeing the red light blinking. So it is recorded. So let me repeat, the objection is untenable because the federal court, in the case of Collector of Customs of New South Wales versus Brian Lawler Automotive, ruled that the jurisdiction of the AAT will not be ousted simply because there is a question of law that seems to be involved. In the process of resolving a case before it, the AAT may incidentally pass upon a legal question and still arrive at its own decision. But obviously, in relation to any statement that the Administrative Tribunal may make on the legal question, that is not final and determinative because only Chapter 3 courts have the power to pass upon questions of law. So if it's incidental, it is permissible. But certainly, the jurisdiction of the AAT will not be ousted simply because there seems to be a question of law that is involved in the process of making a determination on the case before the AAT. And as B pointed out, cannot hold a law as invalid. And so that's right. So certainly, it is not within the power of the Administrative Tribunal to determine whether or not legislation is legal or not. It doesn't have the power because only courts exercising judicial power can do that. So, okay, any questions before we move on to the next? None? Okay. Maggie, can you read this question for us, please?
Yep. In a case before it, the AAT considered evidence and matters that were not before the decision maker. Party X argues that the AAT went beyond its powers. Is this correct?
Okay. Can I get the answer there? Would this be correct? Good. So the answer is no. That is not correct. This is crucial because what sometimes happens is that there may be matters, and I'm using the word matter here in a very loose sense, not from the constitutional viewpoint, not from the viewpoint of constitutional law. So there might be matters, there might be issues, there might be arguments that were not raised with the original decision maker. And what if in making an application for review with the AAT, one of the parties or the aggrieved therefore then raises matters or issues or evidentiary concerns that had not been raised before the AAT, before the original decision maker. Will it then mean that the AAT is therefore powerless to consider evidence that were not before the original decision maker? And the answer is no, because what happens is that if an application is then brought before the AAT is meant to have a de novo hearing. So it's a new hearing altogether. And because it is a new hearing altogether, and the AAT therefore steps into the shoes of the original decision maker and even substitutes its own decision for that of the original decision maker, it is free to consider all evidence and facts, even those which had not originally been considered before the original decision maker. Okay, and from B, no presumption in favor of the original decision. Very good. Thank you. So we'll move on to the next discussion question. We've got two more, I think. Yep, we've got two more. Can I get a volunteer to answer? So that point there about that specific question here, just keep that in mind because that is a crucial point, especially in the context of the final written online assessment, because this keeps on coming up. You always have to determine, what. So that one, as well as the Brian Lawler automotive case, these are crucial principles that you have to remember in administrative law, and they will usually crop up and is likely to crop up again in the final written online assessment. Okay, can I get a volunteer to read question 4 for us, please?
I'll do it, Manjo.
Thank you.
Students protested against the visit of the Chinese Defence Minister to the Australian Parliament in February. When the student protest went out of control, student Josh MacArthur suffered injuries after he was shoved to the ground and kicked by a member of the Australian Federal Police. He filed a complaint to the Commissioner of Police against a police officer who caused his injuries. After an investigation, the Commissioner of Police made a finding that the police officer involved in the incident was not at fault and decided against taking any disciplinary action against the police officer. Josh intends to have the decision of the Commissioner of Police reviewed and has come to you for advice. He wants to know if he can file an application for review to the Administrative Appeals Tribunal. What would you tell him?
Okay. Can I get everyone to post his answers in the chat box? So we've got answers here. Depends on the legislation. What else? I'm just going back up. No, from is likely a decision that's suitable for review. Okay, as being of a law enforcement nature. From Libby, depends on if the legislation specifically allows merit review. Causation in torts. Okay, so what do you think is the answer here? Reviewable or not reviewable? There seems to be a lot of disagreement. What is the key point here? What's the key issue here that needs to be examined? What do you think? The answer for some is it depends on what the legislation provides. So let's assume that there is a law that says that decisions of the Australian Federal Police or the decisions of the Commissioner of Police can be subject to review by the AAT. Let me repeat, because some were saying that it depends on the legislation. So the question is, assuming that there is in fact a law which provides that decisions of the Commissioner of Police can be subject to review by the AAT, would it then mean that it is now open for Josh MacArthur to file an application for review to the Administrative Appeals Tribunal? Yes, on the basis of the facts.
Manjo,
Yes.
is it open? It is open now to him to file an application. It's the decision of the Commissioner of Police, because he's gone and made an investigation, he's found some facts, and he's made a ruling. So he's exercised his discretion, and he's a member of the executive. So who checks his decisions? Who makes sure he is actually doing his job properly? And that's what you want to be helping Josh with. Is that right?
Yes. But the question for me still, the question that I'm still raising, so you point out a valid point there, Audrey, but the question I still would like to ask is, assuming that there is in fact a law which provides that decisions of the Commissioner of Police are subject to review by the AAT, is that sufficient then for merits review to be available? Merits review with the AAT. From Jackie, it must still be of an administrative character. That's right. So that is the answer there, provided by Jackie. It is insufficient, it is not enough that a law provides that decisions of the Commissioner of Police may be subject to review by the AAT. The decision of the Commissioner of Police must still be of an administrative character, or one that is based on an enactment, or that specific enactment, which then provides that a review can be made with the AAT. So you still have to determine, because remember that when a decision maker makes a decision, the decision does not have to be based on an enactment. It can be based on the law of contracts, for example, or it could be based on some other general law. So the only decisions
that can be subject to review by the AAT would be decisions of an administrative character. And we know it's an administrative character if it is neither a judicial decision or a legislative decision. And we're going to go at some point into deeply into what that means. But more importantly, what it actually means is that it is typically of an administrative character if the decision was also based on an enactment. And that enactment also provides that recourse may be had to the AAT. Okay, questions so far? None? And so I'm referring to Section 25, subsection 1 of the Administrative Appeals Tribunal Act of 1975. So final question for tonight. Can I ask for a volunteer to answer discussion question 5 for us, please? Volunteer? Volunteer? Can I get a volunteer to read question 5 for us? Question 5.
No, I'll read it, Manjo.
Yes, please. Who's this? Michael. Thank you, Michael.
Kim Upshot operates a car rental business and has been doing most of the business accounting tasks on her own. An audit by the Australian Taxation Office revealed that Kim had misinterpreted key provisions of the Australian tax laws and as a result was deficient in the payment of taxes in the amount of $4,965. She asked the Australian Tax Office to review her tax liabilities. The Australian Tax Office affirmed its decision and reiterated the reasons for her tax liabilities. She was advised by the Australian Tax Office, however, that the relevant laws allowed her to have the Australian Tax Office decision reviewed by the Administrative Appeals Tribunal. Kim then sought legal advice to determine the next step she would take. A tax lawyer was of the view that a proper interpretation of the relevant tax laws in certain factual matters not brought to the attention before the ATO would show that Kim only owed $2,464. At the tribunal, Kim included in the statement of reasons for her application that the Australian Tax Office interpretation was wrong and that it had failed to consider certain factual matters that would have caused a reduction of her tax liabilities to $2,464. The Australian Tax Office argued that it was not open for Kim to raise these new matters as they had not been brought before the ATO. It argued further that the tribunal's powers of review was limited to the matters and the reasons cited in the Australian Tax Office decision. Who is correct and why?
Thank you. Thank you, Michael. Can I ask everyone again to post his or her answers in the chat box? Who is correct and why? We had an answer from Libby. Kim is correct because what we have is a de novo hearing. How about the others? ITO is correct from Jennifer. Very good. Kim is correct. Very good. Very good. Okay. So that's good. So, yep, everyone is correct there because the rule is, as far as the Administrative Appeals Tribunal is concerned, they have the power to actually, they have the power to conduct a de novo hearing. De novo means as if from scratch, from the very beginning. So, which means, therefore, it is within the power of the AAT to consider matters that, or even evidence that had, and issues that had not been raised before the original decision maker. So from Vicky here, a de novo review allows for the hearing of the entire case, including review of new material and or evidence. So that is the correct statement of the law. And if you look in particular at Section 29 of the Administrative Appeals Tribunal Act, it also provides that the applicant, when applying for a merits review, must state the reasons for the application for review.
And because of Section 29, it also therefore implies that in that statement of reasons, it is within the power of the applicant to raise new matters or raise new issues or issues concerning evidence that may not have been raised originally before the original decision maker. So those are the only questions that I had hoped to be covered tonight. Would there be anything else before we end tonight's session? Would there be any of the matters you wish to clarify before we end tonight's session? So Audrey is shaking her head. Anything else? So we're all good? Okay, so I guess that's it for tonight. So we're gonna have the special tutorial on Friday on the legal memorandum. That's fine, Jacob. I would have wanted to see Jacob's face though. I'll have to look you up again, Jacob. So I thank Jacob because really he's really been very, very active in the discussion forums and has helped get a lot of questions clarified. And he's quite been inspiring to a lot of the students. So well done, Jacob. And well done to the others who have actually been quite supportive to your peers. I hope that continues. So thank you, everyone. And I hope to see you on Friday this week to talk about the legal memorandum assessment. Good night. Bye.